Welcome back to another episode of Dissecting Insurance, and I'm your host Shubhajit. So this will be a special episode for us because for the time being it will be the last episode on Marine series with our respected and beloved Basudev sir. You all know him from our last two episodes and hence needs no introduction. Still, in case you are a very first time listener of our podcast, let me just give you a brief introduction. Basudev sir is a Deputy General Manager in a leading PSU general insurance company and an avid insurance enthusiast. He is not only an accomplished insurance professional but someone who truly enjoys learning about various aspects of insurance and thus has been a great support to this podcast. I take this opportunity to once again welcome Basudev sir. Thank you for being with us, and how have you been, sir?
Well, I'm fine. How are you?
I'm doing good, sir. Thank you.
I'm looking forward to yet another podcast of this very interesting series that's going on, and hope that it will be of interest to those who are, following our podcasts.
Okay, so without further ado, let's get into the main subject of today's podcast. On 9th August 2023, the Indian Supreme Court pronounced a significant judgment on marine insurance in a case involving a claim under a marine hull policy. This case, Hind Offshore versus IFCO Tokyo, drew our attention to a very important subject in marine insurance, that is, the subject of warranties. Today's topic of discussion emanated from Apex Court's discussion regarding this case. However, before jumping into this judgment and its significance, let us first start from the basics and then deep dive into the concepts involved. So, sir, my first question would be, what is exactly a warranty in a marine insurance?
Yes, that's an important or interesting subject. And let me begin by giving the definition of the Marine Insurance Act 1963 as laid down in Section 35 subsection 1 of this Act, which also corresponds to Section 33 subsection 1 of the UK Marine Insurance Act 1906. This definition of a warranty states that a warranty means a promissory warranty, that is to say, a warranty by which the assured undertakes that some particular thing shall or shall not be done, or that some condition shall be fulfilled, or whereby he affirms or negatives the existence of a particular state of facts. According to this definition, warranties include undertakings A as to past or present facts, and that some condition has been fulfilled, which in other words are affirmative warranties, or B as to future conduct of the assured, which are called continuing or promissory warranties.
So, sir, warranty is basically a kind of undertaking. But warranty is a term also used in normal contract. Does it have a separate meaning under normal contract law?
Yes, warranty is interpreted differently in other areas of contract law, as is evident from the definition provided by Section 12, subsection 3 of the Sale of the Goods Act 1930, which states that a warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages, but not to a right to reject the goods and treat the contract as repudiated. In fact, warranty in a marine insurance law is akin to a condition in general contract law. In the context of Section 12 of the Sale of Goods Act 1930, a condition is a foundation of the entire contract and integral part for performing the contract, whereas a warranty is merely a stipulation that is collateral to the main purpose of the contract.
So, sir, this brings us to our next question, whether warranties needs to be explicitly declared in the contract of insurance?
Well, what you are referring to is known as an express warranty. Section 35 subsection 2 of the Marine Insurance Act 1963 acknowledges that there are two categories of warranties, one express and two implied. Express warranties are those which are explicitly written into the policy. Under law, in order to constitute an insurance warranty, it is to be noted that no particular form of words is required. And indeed, the words warranty or warranted need not even be used. The identification of warranty clauses would be dependent upon the intention of the parties as revealed by the contract as a whole. Several kinds of express warranties are typically found in insurance contracts, such as those establishing geographical or trading limits, those warranting the number of crew, and those warranties which are provisions against towage. There are other types of warranties called implied warranties, and the common or the established implied warranties recognized in marine insurance are the warranty of the seaworthiness of the vessel, the legality of the marine adventure, and the warranty against any deviation of the voyage.
Okay, this is very interesting, sir. So, what I understood, it can be explicitly declared or it may not be again explicitly declared. And the most interesting thing that you said, sir, there is nowhere any legal requirement to use that term warranty or warranted.
Yes, you are right.
So, sir, moving on, how are warranties different from representation? That is, the things which are normally declared or disclosed by the insured?
Representations are statements given by the insured during the negotiation of the proposal for insurance. The Marine Insurance Act 1963, Section 2, Subsection 1 states that, and I quote, the assured must disclose to the insurer before the contract is concluded every material circumstance which is known to the assured, and the assured is deemed to know every circumstance which, in the ordinary course of business, ought to be known to him. If the assured fails to make such a disclosure, the insurer may avoid the contract. Unquote. Section 20, Subsection 2 further defines a material fact as, and I quote, every circumstance which would influence the judgment of a prudent insurer in fixing the premium or determining whether he will take the risk. Unquote. In Dehan versus Hartley, a 1786 case, an important distinction was drawn between a representation and a warranty when it was clarified thus, and I quote, there is a material distinction between a warranty and a representation. A representation may be equitably and substantially answered, but a warranty must be strictly complied with. Unquote. It is also significant that representations can be turned into warranties by virtue of what are termed as basis of contract clauses, whereby potential policyholders are asked to sign a clause at the bottom of the proposal form declaring that they warrant the accuracy of all the answers that they have given. The clause usually states that the answers form the basis of the contract. It is well established that such a clause may elevate the answers to contractual terms, even if the terms are not to be found in the policy itself. The use of basis of the contract clauses means that an insurer may avoid liability for an inaccurate answer, even if the answer was not material and even if it was given innocently. For example, in the case of Dawson Limited versus Bonin, 1922, the insured was asked where a lorry was garaged. They inadvertently gave the firm's place of business in central Glasgow, though the lorry was usually kept on the outskirts. This did not increase the risk in any way. However, when the lorry was destroyed by fire, the insurers argued that the accuracy of the answer had been elevated to a warranty. Given the breach, the insurers were no longer liable. The House of Lords agreed that even though the misrepresentation was immaterial to the loss, the insurers were not liable.
Okay. And we can also say that representation is something which is declared from the insured side and has to be accurate to the best of his knowledge, whereas the warranties are something which are conditions given by the insurer that has to be strictly complied with. but breach of either may result in voiding the insurance contract. Will that be an accurate summation of warranty and representation, sir?
Yeah, I think so.
So, sir, just to double click on this aspect, what are the effects of breach of warranty in a marine insurance?
Lord Gough in the Bank of Nova Scotia versus Hellenic Mutual War Risk Association Bermuda Limited case, decided in 1992, said that, and I quote, "A warranty is any term of an insurance contract which, properly construed, is a condition precedent to the inception or continuation of cover," unquote. From this, we may decipher that a warranty has two types of condition precedent. First, a condition which causes the cover not to start, and secondly, a condition which causes it to cease during the duration of cover. Lord Mansfield laid the foundation of the principles of effect of breach of warranty when he stated in the very famous 1778 case of Pawson versus Watson that the warranty was, and I quote, "a term of contract of insurance which must be strictly complied with, and upon any breach of which, however trivial, the insurer is entitled to repudiate the policy," and further that it is perfectly immaterial for what purpose a warranty is introduced, but being inserted, the contract does not exist unless it be literally complied with, unquote. Almost all the rules adopted by Lord Mansfield regarding marine warranties were adopted by the Marine Insurance Act 1906 in the UK and subsequently by the Indian Marine Insurance Act 1963. This can be seen embodied in Section 35, subsection 3 of the Indian Marine Insurance Act 1963, which states that, and I quote, "A warranty, as above defined, is a condition which must be exactly complied with, whether it be material to the risk or not. If it be not so complied with, then, subject to any express provision in the policy, the insurer is discharged from liability as from the date of breach of warranty, but without prejudice to any liability incurred by him before that date," unquote. Thus, it is clear that a warranty in a policy of insurance, particularly in a policy of marine insurance, is a condition or a contingency, and unless that be performed, there is no contract. It is perfectly immaterial for what purpose a warranty is introduced, but being inserted, the contract does not exist unless it be literally complied with. For example, in a case where the policy had warranted that the insured vessel would not travel outside specifically described waters, the insured had argued that a breach of this cross-cruising warranty was immaterial because the actual loss occurred while the vessel was in the appropriately covered waters. This argument failed in court as the law allows breach of even an immaterial warranty to void the policy.
So, sir, it appears that the materiality to the loss is not a factor in case of breach of warranty in marine. What could be the logic behind making this very strict literal compliance of warranties a necessity?
What I can conjecture is that these conditions arose out of the necessity of risks being defined in a contract which was so speculative in nature. It was also felt necessary because the underwriter had to solely rely on the insured for the information that defined the risk.
But we know, sir, that the Supreme Court in India in many instances has decided case against insurance companies where the breach of terms have not been fundamental in nature or not been material to loss. In light of this need for strict compliance of warranty in case of marine, is it not then a contradiction?
Yeah, that is to a great extent a very valid point. The Supreme Court, in cases such as National Insurance Company Limited versus Swaran Singh, decided in 2004, National Insurance Company Limited versus Nitin Khandelwal, decided in 2008, and Lakshmi Chand versus Reliance General Insurance, decided in 2016, has consistently taken the stand that it is not enough for the insurance company to prove that the policy terms have been breached. They must also show that the breach of the policy is so fundamental in nature that it brings an insurance contract to an end.
But none of these were marine insurance cases. Can we examine some of the judgments in more detail?
Yes, you are right. And delving into some of these Supreme Court judgments in non-marine insurance cases, we have the recent judgment of the Supreme Court in India in Texco Marketing Private Limited versus Tata AIG General Insurance Company Limited, civil appeal number 8249 of 2022. This judgment examined the applicability of an exclusion clause in a standard fire and special perils policy. In this judgment, the Supreme Court laid emphasis on a wide array of previous judgments to hold that an exclusion clause cannot be relied upon by the insurer when they are inconsistent with the main purpose for which the contract was entered into by the parties, stating, and I quote, "The main contract, once signed, would eclipse the offending exclusion clause when it would otherwise be impossible to execute it. A clause or a term is a limb which has got no existence outside as such. It exists and vanishes along with the contract, having no independent life of its own. It has got no ability to destroy its own creator, that is the main contract. When it is destructive to the main contract, right at its inception, it has to be severed, being a conscious exclusion, though brought either inadvertently or consciously by the party who introduced it." Unquote. The Supreme Court was following the principle laid down in the earlier case of Skandia Insurance Company Limited versus Kokilaven Chandravada, where it was similarly held that the exclusion of liability clause has to be read down so that it does not conflict with the main purpose of the provision enacted for the protection of victims of accidents. The Supreme Court in this judgment stated that, and I quote, "Even if one were to make a strictly doctrinaire approach, the very same conclusion would emerge in obeisance to the doctrine of reading down the exclusion clause in light of the main purpose of the provision, so that the exclusion does not cross swords with the main purpose. The effort must be to harmonize the two instead of allowing the exclusion clause to snipe successfully at the main purpose."
So one can see in all the cases referred by you that materiality to the loss was indeed a factor. But what would be the position in case of a marine insurance claim? We would like to know in the context of the recent Supreme Court decision in Hind Offshore versus IFCO Tokyo, which was in fact the reason for selecting this topic for today's discussion, and it pertains to a claim under marine hull. And if you can just give us the details about this case, sir.
As far as I know, the Indian Supreme Court in the recent past has considered this aspect of breach of warranty in the context of marine insurance in two cases. One, of course, was the case we have already mentioned, that of Hind Offshore Private Limited versus IFCO Tokyo General Insurance Company Limited, decided on 9th August 2023. The other case is the case of Rajan Kumar and Brothers Impex versus Oriental Insurance Company Limited, which involved a cargo claim and which was decided on 7th February 2020. Coming to the first case, this will require some elaborate discussion. Hind Offshore Private Limited entered into a bareboat charter party agreement with the registered owner of a sea vessel called MV Sea Panther. A bareboat charter party agreement is an arrangement for chartering a vessel where the owner does not provide any crew or provisions to the persons chartering the vessel. Hind Offshore, in its capacity as a bareboat charterer of the vessel, took a marine hull insurance policy for the vessel from the insurer IFCO Tokyo General Insurance, incorporating the standard ITC hulls 11083 clauses. During the currency of the policy, the vessel suffered major damage to its port main engine while on a voyage from Singapore to Mumbai. The appointed surveyor opined on preliminary inspection that the crankshafts and connecting rods were beyond repair. However, due to urgent commercial commitments, the main port engine was only temporarily repaired. The insurer, based on the surveyor's recommendation and the invoice submitted by the insured, paid rupees 1 crore as an advance for completing the repairs. Thereafter, the insured renewed their marine hull policy for another year, and during the validity of this renewed policy, the vessel was unfortunately struck by a tugboat in Mumbai, as a result of which the vessel sank with all cargo on board. The insured submitted a claim for total loss of the vessel, and the insurer got survey done to assess the loss. The vessel was found classed by the American Bureau of Shipping, or ABS, at the time of accident. However, the surveyor's report noted the following. A. The owner of the vessel did not inform ABS about the previous damage to the vessel's main port engine, and ABS had issued the class warranty based only on their physical inspection. B. The country manager of ABS reported that if a vessel sustains any damage to either hull or machinery and the same is not reported to the classification society, then the class would deem to be automatically suspended as per ABS rules for building and classing steel vessels. C. It was concluded in the surveyor's final report that the vessel cannot be recovered and that the permanent repairs to the vessel at the said stage won't be effective, as the same ought to have been done after the first accident itself, which was not done by the insured. D. The surveyor thus recommended that the insurer should recover the advance of rupees 1 crore earlier paid to the insured. As the insured's claim was not settled by the insurer, hence the insured filed a consumer complaint before the Honorable National Consumer Dispute Redressal Commission against the insurer, claiming a sum of approximately 16.62 crores rupees, that is, including interest and costs. When the NCDRC, the National Consumer Dispute Redressal Commission, dismissed the complaint of the insured, they aggrieved by this order, filed civil appeal number 7228 of 2015 before the Honorable Supreme Court of India. The Supreme Court, via its order dated 9/8/2023, that is 9th August 2023, made the following observations. 1. That after the first accident, although the insured had informed the insurer about the damage caused to the port main engine of the vessel, based on which the insurer had paid a provisional claim of rupees 1 crore towards advance for preliminary repairs, it was still the insured's responsibility to subsequently get the complete repair or replacement of the damaged parts done. 2. If the insured failed to subsequently get the complete repair of the vessel done, the same ought to have been brought to the knowledge of ABS surveyor, which the appellant failed to do. The class certificate is supposed to be issued by the ABS surveyor only after taking into consideration all aspects, including the defects, if any, brought to his notice. As per the ABS rules for building and classing marine vessels, the class certificate issued by ABS in respect of a vessel will get suspended or cancelled in case the defects or damage pertaining to the ship or vessel are not reported to ABS before the issue of such class warranty certificate. Third, the two-judge bench of the Apex Court in this judgment said, and I quote, "In that circumstance, when the respondent insurance company relied upon the class certification to issue the policy, there was no express or implied waiver. The appellant has not established that the defects were brought to the notice of the classification society and thereafter the certificate had been obtained. In such a situation where it is subsequently noticed that these defects were not intimated and the warranty class had not been complied, the classification certificate would automatically become invalid." Unquote. The court said that the replacement of the engine crankshaft had not been made and had come to the knowledge of the insurer only when the final survey report was submitted after the policy had already been renewed and thereafter the accident had occurred. As such, there is no waiver on the part of the insurer in this case. 4. From a perusal of sections 35, sections 37, sections 41 subsection 5 and section 55 of the Indian Marine Insurance Act 1963 relating to warranties, the court noted that a warranty is a condition which has to be exactly complied with, whether it is material to the risk or not. Hence, if an insured breaches a warranty, the insurer is discharged from its liability with effect from the date of breach of such warranty. 5. If the ship is sent into the sea in an unseaworthy condition with the privity of the insured, in such circumstances as well, the insurer gets discharged from its liability in respect of any loss attributable to such unseaworthiness. Accordingly, considering all these points, the Apex Court dismissed the appeal of the insured Hind Offshore Private Limited and refused to interfere with the order of the National Consumer Disputes Judicial Commission, NCDRC.
Thank you, sir, for elaborately describing us the case facts. Now, if you can just share with us the noteworthy aspects of this judgment.
Two important inferences that emerge from this judgment are as follows. One, both NCDRC and Supreme Court have opined that the seaworthiness or otherwise of the vessel at the time of accident is not of relevance to the claim. Though the vessel was actually classed on the date of accident, the fact that it was obtained by concealment of the prior damages would render the same invalid under the classification society rules. Therefore, the policy having been issued with an express warranty requirement of valid classification, such invalidity would constitute a breach of warranty and this would render the claim inadmissible. Second, mere knowledge of the insurer that there is a breach of warranty is not a waiver in absence of an express representation to that effect. But there is another aspect that has occurred to me, and if I may be granted the liberty of expressing it here, there has been a revision in the United Kingdom legislative framework on insurance warranties, through the enactment of the Insurance Act 2015. We also know that the Institute Cargo Clauses, the ITC Hulls Clause 11083, and even the Institute Classification Clause, which are usually incorporated with our marine policies issued in India, they contain an express provision that they are subject to English law and practice. It follows, therefore, that the changes in English law would also be relevant to the interpretation of marine clauses in the Indian context, in the Indian context with regard to claims. Therefore, an interesting, albeit merely an academic point of speculation, would be on the possible impact of these legislative changes on the issues involved in these cases.
Sir, you are saying that these changes in the UK legislation involve the provisions on warranties. What are the salient features of these revisions?
First, to give a background for these revisions, it needs to be said that it was felt that the provisions on warranties embodied in the English Marine Insurance Act 1906 had become obsolete. In fact, the UK Law Commission revealed that in the consultation process about insurance warranties, 88% of the respondents related to the industry agreed that there was a need to reform the law in relation to sections 33 and 34 of the Marine Insurance Act 1906. The Law Commission in its report highlighted the general view that the United Kingdom was out of sync with the global market practices. It can be said that the revised Act heralds a new era for marine insurance warranty law in the UK, with significant changes being effected. To give a detail of these changes, we can say that firstly, the old strict compliance principle in marine insurance warranties has been fundamentally changed. Under the new Act, the result of a breach of warranty is the suspension of liability of the insurer under the contract of insurance and not an automatic discharge. Therefore, insurers are not obliged to pay for a loss occurring during the period when the suspension was in force. But if a loss occurs subsequent to the remedy of the breach, then liability of the insurer is not affected. For instance, regarding a warranty that there should be 5 watchmen at all times, there will be no cover while the vessel breaches the warranty on the number of watchmen, but the cover will be reinstated as soon as the breach is corrected. Secondly, very importantly, the basis of the contract clauses in insurance contracts has been abolished. These clauses effectively turned the contents of a proposal form into a warranty and meant that an insurer could avoid a claim based on the fact that one of the statements of the proposal form, even on a trivial or an immaterial issue, was inaccurate. Under the new Act, any representation made by the insurer is not liable to be considered as a warranty unless they are expressly mentioned in the contract of insurance or the policy. Finally, the causation rule is adopted for marine insurance warranties. The non-compliance with a term designed to reduce the risk of a particular type of loss or of a loss at a particular time or in a particular place, which is demonstrated to have not potentially increased the risk of an occurred loss, does not exonerate the insurer's liability. Therefore, the insurer is not able to rely on any defense which is not material to their loss, with the exception that this is not to be applied for terms that define the risk as a whole. As an example, we can say that if the warranty states that the vessel should have fire alarms and the vessel sinks because of any reason not related to the fire, then the insurer is not able to refuse payment of the claim.
Sir, then do these changes imply that the proposal form is no longer part of the policy itself if the contents of the proposal form are not explicitly mentioned in the policy?
Yes, that is the position in the UK now, that unless it is expressly mentioned in the policy, no representation becomes a warranty.
Sir, these changes are quite radical to be honest and will certainly affect the way breach of warranties are perceived under the law. Any other modifications of relevance that you can mention?
A very important change brought about by the new act is in the duty of disclosure. As we know, the duty of disclosure is one of the most important aspects of insurance law, based on the principle of utmost good faith, with its roots traceable to the 18th century when Lord Mansfield, whom we have referred to earlier, stated that, and I quote, "Good faith forbids either party, by concealing what he privately knows, to draw the other into a bargain from his ignorance of that fact and from his believing to the contrary." Unquote. In the UK Marine Insurance Act 1906, in Section 18, corresponding to Section 20 of the Indian Marine Insurance Act 63, it was stated that the policyholder must disclose, quote unquote, every material circumstances that he, quote unquote, knows or ought to know to the insurer before signing a marine insurance contract, and that a circumstance is material when it, quote unquote, would influence the judgment of a prudent insurer in fixing the premium or determining whether he will take the risk. Thus, under the old provisions, it is the assured who was required to play the active role without being questioned or told what is necessary to disclose and what is not. On the other hand, the passive role stipulated for the insurers in this matter enabled them to ask questions even after the happening of a claim, and in the event of even a minor breach of the duty of disclosure, the insurer could avoid the contract as if it had never existed at all. Sections 18 and Sections 20 of the Marine Insurance Act 1906 on non-disclosure and misrepresentation were therefore deleted in the Insurance Act 2015 and replaced with the newly enacted section, that is Section 3 of the Insurance Act 2015, incorporating the new concept of duty of fair presentation, applying only to non-consumer or business insurance contracts. The duty of fair presentation requires the insured party to A. disclose every material circumstance which the insured knows or ought to know, or B. failing that, disclosure which gives the insurer sufficient information to put a prudent insurer on notice that it needs to make further inquiries for the purposes of revealing those material circumstances. However, if no inquiry is made, then it is not necessary for the insured business to disclose a circumstance if A. it diminishes the risk, B. the insurer knows it, C. the insurer ought to know it, D. the insurer is presumed to know it, or E. it is something as to which the insurer waives. Further, it is clarified that the insured ought to know information that would be revealed by a reasonable search of information available to it. The disclosure has to be made in a manner which would be reasonably clear and accessible to a prudent insurer. And every representation as to a matter of fact is to be substantially correct, and every representation as to a matter of expectation or belief is to be made in good faith. Section 5 of the Act sets out the meaning of the insurer's knowledge and provides that the insurer knows what is known to individuals who decide on behalf of the insurer whether to accept the risk in question. Thus, the knowledge of the insurer's claims department may also be deemed to be knowledge of the insurer. Combined with the option given to the insured under Section 3, subsection 4, to disclose only that which would put the insurer on notice of the need to make further inquiry, this means that the insurer will need to take a more proactive role in the disclosure process. The insurer's knowledge will include that which, and I quote, an insurer offering insurance of the class in question to insureds in the field of activity in question would reasonably be expected to know, unquote. In other words, general knowledge. Section 6 of the 2015 Act clarifies that knowledge includes not only actual knowledge but also what is termed as blind eye knowledge, matters which the individual suspects but deliberately chooses to ignore. For example, defects in a vessel which are actually known to him. Failure to disclose such knowledge could also amount to a deliberate breach of the duty to make fair presentation. Section 7, subsection 3 of the new Act states that an objective test would be applied to determine whether a circumstance or a representation is material or not. Thus, the question would be whether the representation would influence the judgment of a prudent insurer in determining whether to take the risk, and if so, on what terms. In addition, Section 7, subsection 5 also noted that a material representation is substantially correct if a prudent insurer would not consider the difference between what is represented and what is actually correct to be material. The remedy of complete avoidance under the 1906 Act for a breach of disclosure obligations is abolished in the 2015 Act and replaced with a proportionate system of remedies for breach of the duty to make a fair presentation. The new Act gives the insurer a remedy when they would be able to show that but for the breach, the insurer A would not have entered into the contract of insurance at all, or B would have done so only on different terms. If any of the above criteria are met, the breach will be a qualifying breach, and the available remedy will depend on whether the insured knew it was in breach or did not care whether it was in breach. This is nothing but a deliberate or reckless breach as per the Act, and the insurer would have the remedy of avoidance of the contract from inception in such cases and be able to retain the premium also paid by the insured. Where a qualifying breach is not deliberate or reckless, the available remedy under the Act would have the object of putting the parties in the position they would have been in had a fair presentation been made. If the insurer is able to establish on the balance of probabilities that they would not have underwritten the risk at all, the remedy will be avoidance from inception with the premium being returned to the insured. However, if it is found that the insurer would have entered into the contract but on certain different terms other than the amount of premium, then the contract is to be deemed as if it had been entered on those different terms. Additionally, if the insurer would have entered into the contract but the rate of premium would have been higher, irrespective of whether the terms relating to matters other than the premium would have been same or different, then the insurer would be able to reduce that amount proportionately from the claims made, if any.
Sir, it is evident that the sweeping changes in very significant areas of insurance law have been affected by the new Insurance Act 2015 of the UK. You had earlier referred to the Hind Offshore versus IFCO Tokyo case. Do you think that the new Act provisions on warranties should have been considered in this case?
That's a very interesting question, but I would have to say probably no, as the date of accident for the disputed claim was 3rd December 2006, which was several years before the enactment of the new Act in UK on 12th August 2016. However, it would be interesting to speculate on the possibilities if, under the same circumstances, a claim had occurred after 12th August 2016 and had been similarly disputed.
So in such an event, would the conclusion of the Supreme Court could have been different?
That is indeed difficult and perhaps risky to predict. At the outset, let me point out that in the judgment in the Hind Offshore case, it is stated that, and I quote, "From a perusal of the provisions contained in the Marine Insurance Act 1963 relating to warranties, if the requirement is not complied with, then the insurer is discharged from liability as from the date of breach of warranty, but without prejudice to any liability incurred before that date, unquote. It is pertinent to note here that the provisions referred above, that is section 35 subsection 3 of the Marine Insurance Act 1963, have been deleted in UK with the enactment of the New Insurance Act 2015. Having said that, it is my opinion that the conclusion by the courts, even under the provisions of the New Insurance Act 2015, would most likely remain unchanged. The reason is that though Section 11 of the Revised Insurance Act 2015 provides that if a loss occurs while a warranty is not complied with, the policyholder may still be indemnified if he can prove that non-compliance with the term could not have increased the risk of the loss, which actually occurred in the circumstances in which it occurred. But this section does not apply to terms that define the risk as a whole. It has been a generally held view that the classification warranty is a warranty that defines the risk as a whole. As opined by Barris Soar, in case of non-compliance with such a warranty, the entire coverage must be suspended for the duration of the breach. The classification of the vessel is also likely to be considered a material circumstance even under the new Act, and the insured cannot escape from the duty of disclosure on this fact. A breach of this warranty under the circumstances of the Hind offshore case would almost certainly be deemed as a deliberate and reckless breach of fair presentation, giving insurance company the right to avoid the contract.
Sir, we find in this case that no nexus was established between the breach of warranty and unseaworthiness resulting into the loss. Further, technically there was a class certificate valid at the material time issued based on inspection of the vessel, and the concealment alleged is not directly with the insurance company but rather with the classification society. Under this circumstance, the judgment appears, to be very honest, a bit harsh on the insured and seemingly based solely on the provisions of the very strict compliance of warranties laid down in the Marine Insurance Act of 1963. What do you feel, sir?
While reserving my comments on the Hind offshore judgment per se, I would put forward my view in this matter by stressing three main aspects. One, in his presentation to the Canadian Ferry Association's Conference and Trade Show on 16th September 2019, IACS, that is Institute of Association of Classification Societies Secretary General, Mr. Robert Ashdown, had stated that, and I quote, "A class certificate is an attestation that a vessel is in compliance with the rules that have been developed and published by the society issuing the classification certificate. Further, classification societies are not guarantors of safety of life or property at sea or the seaworthiness of a vessel, because the classification society has no control over how a vessel is manned, operated and maintained between the periodical surveys which it conducts." Unquote. Thus, we have to understand that classification certificate ensures a certain standard of seaworthiness of the vessel based on the compliance of rules of the classification society, but is certainly not a guarantee of seaworthiness. Number two, seaworthiness of a ship is defined in section 41, subsection 4 of the Marine Insurance Act 1963, which states that, and I quote, "A ship is deemed to be seaworthy when she is reasonably fit in all respects to encounter the ordinary perils of the seas of the adventure insured." Unquote. The state of seaworthiness is a relative and not an absolute state. There is seaworthiness for the port, seaworthiness in some cases for the river, and seaworthiness in some cases for some definite, well-recognized and distinctly separate stage of the voyage. Again, a ship may be seaworthy in herself, but not seaworthy for the purpose of a particular adventure, for example, for the carrying of deck cargo. Section 41, subsection 5 of the Marine Insurance Act 1963 provides that in a time policy there is no implied warranty that the ship shall be seaworthy at any stage of the adventure, but where, with the privity of the assured, the ship is sent to sea in an unseaworthy state, the insurer is not liable for any loss attributable to unseaworthiness. 3. Digressing to other spheres of insurance law, we can note the observations of the Supreme Court in the case of National Insurance Company Limited versus Swaran Singh and others, decided in 2004 concerning liability for motor accident compensation. And I quote from the judgment: even where the insurer is able to prove breach on the part of the insured concerning the policy condition regarding holding of a valid license by the driver or his qualification to drive during the relevant period, the insurer would not be allowed to avoid its liability towards insured unless the said breach or breaches on the condition of the driving license is or are so fundamental as are found to have contributed to the cause of the accident. Unquote. Again, in B.V. Nagaraju versus Oriental Insurance Company Limited, the Supreme Court stated that, and I quote, merely by lifting a person's or two or even three by the driver or the cleaner of the vehicle without the knowledge of the owner cannot be said to be such a fundamental breach that the owner should, in all events, be denied indemnification. The misuse of the vehicle was somewhat irregular, though, but not so fundamental in nature so as to put an end to the contract unless some factors existed which by themselves had gone to contribute to the causing of the accident. Unquote. Now, a condition requiring a valid license to drive a vehicle or not allowing carrying of outside persons in a goods carrying vehicle are simply reiterations of important motor vehicle statutory conditions or rules. However, even here it is noticed that breach of these conditions are not found to be valid grounds for avoiding liability in an insurance claim. In this regard, two further onerous duties are put before the insurer. One, to prove that the insured is privy to the breach. Two, to prove that the breach was of such a fundamental nature that it contributed to the happening of the accident. Under such circumstances, where the class of a ship is only an indication but not a certificate of seaworthiness, allowing an insurer to avoid complete liability even in a cargo claim, like the one in Rajan Kumar Brothers versus Oriental Insurance, only on the basis of non-compliance of classification clause, without going into the issues of A, whether the vessel was merely unclassified or also unseaworthy at the material type of accident, B, if found unseaworthy, whether the unseaworthiness of the vessel can be attributable to the accident, C, whether the insured was privy to such unseaworthiness. All these is, in my opinion, very questionable and inconsistent with the main purpose, principle, or the fundamental breach rule which are found enunciated in other Supreme Court rulings.
So, sir, my last question will be, under these circumstances, do you think that the law on warranties in India should be amended like in the United Kingdom?
The 1906 Act in UK was drafted at a time when the insurance industry there was finding its feet, and when there was a concern about the possibility of deception by the insureds. Consequently, it confers wide-ranging rights upon the insurers to refuse claims or to treat their liability as discharge, which today, to the modern eye, seems disproportionate to the breach committed by the insured. The 2015 Act in UK had its central aim as the creation of a fairer balance between the interests of the insurer and the insured. The Insurance Act 2015 introduces some new concepts, and along with that, considerable uncertainty. For example, the concept of Section 11 of the whole risk is a new one, and both the insureds and the insurers can expect legal challenges until the courts have resolved what exactly it means. Under the new act, it is possible for the insurers to contract out of most of the new provisions, and therefore the new act creates only a default regime. Overall, it can be said that many in UK would agree with barrister Mr. Peter MacDonald Eggers' comment that the new Act of 2015 in fact failed to achieve Parliament's objective of making the law less insurer friendly and of making the remedies proportionate. The general view is that the UK Act 2015 is not satisfactory or final, and hence more changes or revisions are expected. In India, the insurance sector is going through a stage of reform and changes, and IRDA in particular has taken on a very ambitious project of insurance for all by the year 2047. Insurance Act is also slated to be amended shortly. It is the right time, in fact, to bring a revised Marine Insurance Act in place. We know that our Marine Insurance Act is nothing but an almost a replica of the UK Marine Insurance Act 1906, and this parent act has already been found to be too rigid and obsolete by the Law Commission there, and consequently revised after almost a century of its existence. It would be beneficial for the Indian insurance industry if we follow in line with the global trends by effecting changes which would replace the archaic provisions of the old act with a clear, unambiguous, unbiased and more customer-friendly legislation in marine insurance.
Thank you, sir. Thank you for your opinion. And like you said, that the world has moved on and every industry is now focusing more to be customer friendly. And insurance industry also cannot be an exception to this. So I guess from what you said and your opinion, we can summarize that as a whole, as an insurance industry as a whole, we should aim to make our every legislation, every policy wording or every process more and more customer friendly.
Yes, and I think as I explained, this legislation in marine is actually though it is in India, it has been introduced only in 1963. It is actually a century old because it's a copy of the UK Marine Insurance Act. So a century old legislation, in such a dynamic environment, it definitely needs a change very badly.
Exactly. So with this, we have reached the end of our today's podcast. Thank you, Basudev sir, once again for this enlightening session, and thank you for listening to us. Thank you.
Thank you. Till we meet again.
So that wraps it up. Once again, thank you for listening to our episode. Keep supporting us and keep dissecting whatever makes you curious.